Floyd. I'm Mike Duffy. Joining us tonight to discuss today's proceedings are civil rights attorney John Burris, who specializes in policing cases, and Timothy T. Williams Jr., former LAPD detective, police procedures, use of force, and wrongful conviction expert, and author of the book, A Deep Dive. Thank you both for being with us.
Thank you. Good to be with you.
Thank you for having us.
So opening statements happened today, and the state and Chauvin's defense team laid out their cases. Let's take a listen to what we heard, and then we'll discuss it.
You will learn that he was well aware that Mr. Floyd was unarmed, that Mr. Floyd had not threatened anyone, that Mr. Floyd was in handcuffs, he was completely in the control of the police, he was defenseless. You will learn what happened in that 9 minutes and 29 seconds. The most important numbers you will hear in this trial are 929.
A reasonable doubt is a doubt that is based upon reason and common sense. At the end of this case, we're going to spend a lot of time talking about doubt. But for purposes of my remarks this morning, I want to talk about reason and common sense and how that applies to the evidence that you're about to see during the course of this trial.
And of course, that was just a snippet of what we did here today, but I'll start with you, John. What did you think about opening statements today?
Well, I thought the prosecution did a very nice job of laying out their case, put it in a very straight, direct manner. I thought the prosecutor had some nice comments to make that sort of organized his thoughts and making it a police case that was simple and organized about a victim who was, in fact, who died as a consequence of police conduct, and basically making sure that there were not other extraneous areas in the case, such as the sociological conditions, the race issues. None of that really matters from the prosecution's point of view because they see their case strictly in terms of police misconduct. On the defense side, though, I thought the defendants did what he had to do in terms of to show that there may be other factors, causation issues in terms of the death, police practice issues that might be there. The crowd might be part of it. And also George Floyd himself have contributed largely to this environment in which he found himself in. As they would always say, all he had to do was cooperate. So from my point of view, the prosecution did a very nice job in putting their case, but I thought the defense also laid out some things that a jury could, in fact, give some thought to later on if there's evidence to support it.
Okay, and Tim, same question. What was your reaction to the opening statements?
Well, I think that the prosecution, they laid out, again, I agree with John Burris, that they had a very coherent approach at how they're going to deal with the case. What caught me by surprise, because of the 9 minutes and 29 seconds, the public has heard the 4 minutes or the 8 minutes and 46 seconds, but they had a little bit more than what the public has seen, and it was very telling. I'm interested to see what the police procedures expert is going to do as it relates to this case. And then again, on the other side, on the defense side, what was very clear to me, and John, maybe you can agree with this as well, that it was a two-theme case on the defense side. One was common sense, and the other one was reasonable doubt. And he's trying to. His goal is perhaps to get a hung jury, if you will. But I think that the prosecution's case is strong.
Tim, I just got to stop you down here real quick. We're going to have to cut out for the news at 6:30
today, and it's very interesting to see how.
We'll be right back. Join us for the conversation on abc10.com and on our YouTube page. We'll see you there. Thanks for staying with us as we discuss the trial of former Minneapolis police officer Derek Chauvin, accused in the death of George Floyd. I'm Mike Duffy. Our guests tonight are John Burris, civil rights attorney who specializes in policing cases, and Timothy T. Williams Jr., who you were just listening to just a moment ago, former LAPD detective, police procedures, use of force, and wrongful convictions expert, and author of the book, A Deep Dive. Now, Tim, I did have to cut you off there at last second, but what were you saying at the end there about the proceedings today?
Yeah, as they had the third witness, I call it the martial arts expert. It's going to be interesting to see how the defense handles that. I believe he wasn't an expert, but he presented as an expert, and the judge allowed all this expert testimony to come in. So it's going to be interesting to see how the defense handles that.
Yeah, that was a peculiar moment that we saw in court today. The other thing that I wanted to ask you guys both about is, we haven't really seen the jury. We're not going to see the jury. They're taking great efforts not to. But let's just talk about the makeup of what we know about the jury at this point in time. John, I'll start with you.
I actually think that it's a very good jury in terms of racial composition. I would have been very surprised if they've gotten 4 ethnic minorities on a jury of 12 in Minneapolis. And I thought that the examination of these witnesses, as they went through voir dire, as they call it, was actually pretty good. You can't get witnesses who have never heard of it. The question is, can they put some of this aside? And I thought that this seems like a jury that could do that. And if I'm the prosecution, I think I got a pretty good jury. I mean, it's always nervous for the prosecution in plaintiff cases because they're concerned that they may have people who are so committed to the police that they can't overcome that particular bias. But that's the chance you have to take when you got a case that has so explosive evidence in it and everybody has seen it and you know you have to overcome it. So I thought that the jury composition itself was actually pretty good.
Tim, do you have any feelings about that?
Yeah, I think the jury is good. I've been doing this stuff going on 47 years now. And, you can't predict what a jury is going to do. And they're going to look at all the people that are coming before them. The experts are going to play a major role in this case. And it's going to be an issue of credibility. It's going to be an issue of credibility and how it's being handled and how the experts handle themselves in cross-examination and so on and so forth.
I think, though, that what's critically important for the prosecution, their case is going to go in pretty well. I mean, they got the evidence. It will be there. They got a sympathetic client, the decedent. But what's going to be important on the question of reasonable doubt, whether the prosecution, can overcome the defense case. And what that means to me is that they have to show that their experts are not really credible on this particular issue, or they're not particularly relevant on this issue. Because there's going to be a police practice person. That police practice person has got to say that the method that was used by Chauvin was okay, was legitimate. But if another person comes in who's an expert says no, not, like Mr. Williams might do, well, then that would hurt that particular issue, and that then falls back on common sense for the jurors. You're going to have the same thing around cause of death. The causation issue can be a red herring here, because what the causation, he's going to say that he had health conditions, there was alcohol, there was drugs involved, etc., and that none of that, all of that was significant in terms of the cause of death. But that doesn't have to be the only reason for death. The positional asphyxia can, in fact, be a substantial factor. So what the prosecution has to do is try to neutralize as best they can these issues that the defense is putting forth, so that some other one or more person on the jury don't see that as a way out. And that's the challenge. Their case is going to go in fine. The real question is, can they neutralize and minimize the power of the defense arguments? And I think they can do that.
Well, let's talk about the charges that they're going to be up against. Derek Chauvin, right now, he's charged with second-degree murder, third-degree murder, and second-degree manslaughter. So let's start with him. Do you think that these charges will stick, any of them?
Well, the thing is that one thing I liked about the prosecution, they didn't overcharge. They put out the major charges that they want the jury to look at. And I think that with what they presented, I think that there's a good chance, there's a more than a good chance that they will prevail. And just like Mr. Burris said, the prosecution has got to strategize on what the defense is going to do. And I think you got a little hint of it today when the defense attorney talked about the petechial hemorrhaging that was absent. Now he's laying a groundwork to do away with this asphyxiation issue, and I've seen a lot of this, and the thing is, and I think Mr. Burris can agree with that the defense is laying out this issue of reasonable doubt real quick, and he talked about this positional asphyxiation. Petechial hemorrhaging, and so for the audience knows what that is anytime there is a strangulation or a choking, the petechiae, especially in the eyelids, blood vessels, eyelids, they break, and it's called petechial hemorrhaging.
You don't have to have that necessarily for positional asphyxia. Yes. And what he's basically saying is that you're supposed to have it, but you don't have to have it, and that's what they're going to have to overcome. But I think the whole health issue is a big issue as well that the prosecution has to overcome and neutralize. And that's the question of his heart condition, his drug history, all these things that he has that can contribute to weakening his physical system and therefore making him extraordinarily vulnerable. Now, they're going to have a medical person to come in and say that these could have been the cause of death as well. And the prosecution has to overcome that. And they can, but they must have somebody to testify and offer up that estimate. That's why you're going to have this battle of experts. And we have this, as Mr. Williams knows, we have almost in every one of our cases. It's a battle of the experts and what makes more common sense. Ultimately, the jury is going to look to see, what do they think about this officer? I think that the officer has a problem that will hurt him, and I think that will contribute to the cause of conviction. And that's the last 4 minutes. The last 4 minutes of this case, when it was clear that Mr. Floyd was unconscious or not moving, and there were people who were trying to provide help, and he totally ignored it. He looked as if he was disinterested. That will cause a jury to say, whatever was going on before, you stepped across the line in terms of caring for this person, and therefore you can be held accountable on one of the charges.
If I can add one more thing to what Mr. Burris was saying, if you look at the video that was playing, the minutes that we didn't see in the public, when the paramedics came, the officer Derek did not move.
Did not move.
Right. And they were trying to check his pulse, check his vitals, and he didn't move.
Yeah.
To me, that's very telling.
I think that's his death knell in this case. I mean, you're going to go through all these other things, but at the end of the day, did you care? And that was the thing that the prosecution used. You're supposed to care, and you're supposed to get up and stay up. Those are things that will ride throughout this case, and the defense has got to somehow make that count for less, because they got to poke holes in the case. But if everything else is equal, in this case, I think that the last 4 minutes and what he didn't do and should have done will hurt him the most.
Well, let's
help the prosecution.
Let's talk for a second about use of force. Obviously, that's going to come into play. We haven't quite heard much of it yet. But Mr. Williams, what do you think? Did Chauvin use his training? Did he cross the line? What's your opinion at this point?
Well, as the prosecution stated, they talked about the reverence for life, and the policy says sanctity for life. And the use of force has to be emphasized. You have to go with what the policy says, and the policy says here the amount of and type of force that would be considered rational and logical to an objective officer on the scene, supported by facts and circumstances known to the officer at the time the force was used. There's also an issue of duty to intervene. Now, the three other officers, they bifurcated this case, which may have been a good strategy, but there's a duty to intervene, and which was not seen there. And they may stay away from that. I don't know. I will yield to Mr. Burris on that, but the duty to intervene is a huge thing in this case as well.
Well,
I will say on the force question that the way the prosecution laid it out, that you have to consider every moment as whether or not it was appropriate to use force at that moment in time. Right. And he was basically saying you can use force at the beginning, but somewhere it might be during the middle or at least toward the end, no force should have been used. And if so, then the question is, how do you make that analysis? Now, I would look at that and say, if you said that that force was appropriate at the beginning because you're trying to get control of him, somewhere along the line, that force was not appropriate to be used. And where is that? Because after that moment, that's where a reasonable officer should have known that the force he was using was unreasonable. And that's where the liability would come in. That may come in after that last 4 minutes that we didn't know anything about, those last few minutes. But
well, it may come into play. Yeah, it may come into play as soon as he was handcuffed.
Yeah, it could be, right.
Yeah,
once he was handcuffed, right.
Well,
yeah.
What about a knee? Is a knee ever appropriate?
No.
I don't think the knee is appropriate at all. And I've had several cases, particularly on the neck. I mean, that's when you think about putting pressure on the neck, you really are compromising a person's airways. It may not be 10 minutes or whatever, but you are compromising them. And depending upon the person's condition, you could cause that person to go unconscious in a very short period of time. You remember this, you got to take the victim as you find them. It may be that he has a compromised health system. So what? That doesn't justify the police officer's conduct. It only means that when you engage in that conduct, you take the victim as you find them, and it may not help It may not be the same for a person who was in physically good health at 25 versus a person who's 45 and who's in poor health. The results are the same if your conduct has contributed to his death.
That's right.
Well, let's just fast forward here. I know we're in the early stages of this case, but who do you think has the stronger case right now, Tim? Why don't you start?
Well, I think right now the prosecution has a stronger case, but as you well know, tomorrow may be a good day for the defense. The prosecution may have 2 good days, and the defense may have 3 good days in a given week. It goes back and forth. And
Well, I think this, Mr. Williams, I think as a prosecutor, as a plaintiff lawyer and former prosecutor, the prosecutor and the plaintiff in this case has to have good days almost every day.
yes,
Because they're presenting the case.
that's right.
Now, they have to prepare themselves how they're going to neutralize the defendant, and they may do that. But you better be winning this case clearly. You got to get a long head start in it. The way I look at it, this is not an even deal. You got to get a big head start, and so far they're starting out that way. And if you falter somewhere along the way, then you create. If you falter during your case, the prosecution's case, they have created reasonable doubt in the middle of their case.
Right.
There should not be reasonable doubt when you're presenting your case.
Yeah.
That has to become developed on the part of the defense at some later point. At a point.
Yeah.
So the prosecution has the better hand now, and they should have the better hand now. But it's at the end of their case, we'll see, and then we'll see what happens at the end of the defendant's case.
Well, I'm interested to see how the defense is going to handle this martial arts expert that's on the stand. You see, and that is something that I'm sure that they're thinking about, the prosecution, because they're going to get a bite of him tomorrow.
Yeah.
And if they do their homework, they don't know what they're going to find. So they have to be able to be in the position to rehabilitate them and to bring them back to the prosecution side.
Yeah.
Well, it'll be a challenge. You don't want your witnesses to get too beat up on the prosecution side of the case.
Yeah.
Because then you have the jurors start thinking about if this is the best you got, if this is what you're bringing to us. So you want to be less. I'm a firm believer, having presented, less is best. You don't need to present every ounce of evidence you think you have, because the positive evidence may have more negatives associated than not. And so I would be careful about presenting witnesses like him that I think that may present well. And the other thing you're going to have is on the family too. If they bring a lot of evidence on his family, well, you don't know what's going to come out with the family. You could change this whole case around, dynamics, if they start focusing on George Floyd and his family and his relationship. So there's danger here for the prosecution. Less is best.
All right. Well, I guess we'll leave it at that. Of course, there is so much more to discuss, but we're out of time tonight. I just want to say thank you to our experts tonight, civil rights attorney John Burris and Timothy T. Williams, Jr., former LAPD detective and author of A Deep Dive, an expert analysis of police procedures, use of force, and wrongful convictions. Thank you both so much for joining us.
Take care, Tim. We talk later.
All right.
Okay, very good. Take it easy now. Okay.
And for everyone joining us, the conversation continues tomorrow in day 2 of the Derek Chauvin trial. Good night.